We are broadcasting live from the greater DC area, and we welcome our listeners, our viewers from around the country, and indeed around the world. I see we have some international visitors today. My name is Shirley Collier. I'm the president and founder of Scale to Market and host of the Growth Masters Federal podcast. My very special guests today to help me with this topic are Catherine Hickey with the law firm of McDonald Hopkins and Andrew Scherer with Scherer Partners. So Andrew and Catherine, please tell the audience a little bit about yourselves. Ladies first.
Thank you, Shirley. It's very much a pleasure to be here with you today, and thank you to everyone for joining. As Shirley mentioned, I am a partner with the law firm McDonald Hopkins, and my practice consists primarily of working with small business federal government contractors, in particular in the mergers and acquisitions space. So what we're going to be talking about today with respect to the new proposed SBA rules has a significant impact on small business government contracting M&A, which I, for one, have been getting a lot of direct questions from my clients on. And so hence we thought as advisors to this community that this would be of value to those of you who have lots of questions we hope to get into. So been working with these types of companies for years and love the industry. And thank you so much, Shirley, for having me. Andrew?
Thank you, Catherine. Andrew?
Hi, I'm Andrew Scherer with Scherer Partners. We are an M&A broker firm, and more than half the work we do is with government contractors. So to us, this is an incredibly important topic, and I very much appreciate the opportunity to have been invited to speak today with my good friends Shirley and Catherine. As a firm, there are three of us. All of us have been doing this for a very long time. Similar to Catherine, we work with smaller government contractors, which we would define as, say, 50 million in revenue and under, and regularly work with companies that support all the various agencies within the federal government and all across the country. So thank you.
Thank you, Andrew. Just a little housekeeping before we get started with our discussion. We're going to have some remarks, and then we're going to open up the floor for discussion for Q&A. But as we're talking, if you think of a question, please use the chat feature to ask us that question, and we'll get to it as soon as we conclude our very brief remarks here, comments. So to tee up the conversation, in late August, the SBA published proposed rules that make certain changes to their socioeconomic government contracting programs. What we are discussing in this half hour are the implications of those proposed changes to the SBA's recertification rule, plus a few other comments that were in there. So to begin, Catherine, what is your understanding of the current rule, and how does the proposed rule regarding recertification different?
Thank you for clarifying with regard to recertification, because the proposed rule is much more broad-reaching, and we will touch on some of the areas in the proposed rulemaking that go beyond recertification. But the most important, what we would consider a change and a shift that's going to have an impact in M&A specifically, is the change in the recertification process in particular. So the current state of the rule on this topic states that for any government contractor that holds small business set-aside contracts that undergoes a change of control transaction, which would be, a sale of a majority ownership stake in the company, within 30 days following the closing of that acquisition, you are required for any small business set-aside contracts to recertify to the customer your size status. If following the acquisition, you are not able to recertify as small because you are now, for example, affiliated with a large buyer who has acquired your company, then for the most part, under the existing rule, that will impact the agency's ability to take small business set aside credit for the work that you perform post-closing, but in most cases, it does not impact your eligibility to continue performance on both the existing period of performance for that contract, as well as for future option years, and in most cases, to be eligible for additional task orders that might be issued under a multiple award contract vehicle. The new rule is going to change a small business's ability to continue performance of work for set aside contracts in a situation where it can no longer recertify as small post transaction. The change is going to specifically impact multiple award contracts, which the SBA in this context is using to refer to awards of contracts where for that overall primary contract vehicle, there are multiple awardees. So a lot of times we commonly use multiple award contracts to refer to any contract vehicle on which you would have to submit bids for subsequent task orders, like an IDIQ or something along those lines. In this context, the SBA is distinguishing between a single award contract where your company is the only awardee of that contract, and multiple award contracts where that contract primary vehicle is awarded to multiple awardees. And then those multiple awardees under each of their specific primary contracts would have the ability to bid for future task orders, et cetera. In this case, under the new rules, for a single award contract holder, nothing really has changed. You are still eligible for option year exercises. You are still eligible to bid for future task orders on that award, even if you can no longer recertify as small. For contracts that have multiple awardees, the SBA has taken the position that post-acquisition, if you can no longer recertify, you would not be eligible to bid on future task orders, and you would not be eligible to perform on as yet unexercised option year periods. So it's a significant change. I'll stop talking there because we'll get a little bit more into the details later on in this conversation.
So, Catherine, what is the SBA's thinking?
I get this question a lot because the frustration that I find many small business owners hold is this feels as if it is running contrary to the SBA's purpose in promoting the success of small businesses. An exit transaction, an M&A transaction, is often the benchmark of success as a business grows. And this provides a deterrent to that, or at least makes it materially more difficult for the small business holder. The SBA's perspective, and I don't necessarily agree with this, but just so that we can understand their logic behind it, is that the policy mission of the Small Business Administration is to make sure that small business set-aside dollars get paid to small businesses. So from their perspective, once an owner takes on, large outside investment and is no longer small under the size standard, it's contrary to the SBA's mission to continue paying them small business set-aside dollars. And so this rule is intended to further that mission of making sure that they get set-aside dollars to the businesses that are eligible while they are performing. The ripple effects, I would tend to believe, run contrary to the SBA's broader objective to promote the growth and success of small businesses. But that is the logic behind this particular rule change.
So speaking of M&A, Andrew, this is your area of expertise. So what is your opinion on how this would impact government contractors undergoing mergers or acquisitions?
Well, it's going to have a significant impact because it's going to meaningfully decrease the pool of potential buyers. Right or wrong, one exit path or one way to access a slot on some of these multi-award contracts has been for larger companies to go ahead and buy smaller companies after they have won a spot in those contracts, because, as Catherine explained, they would still have the ability at that point to bid for task orders. Given that the proposed rule would eliminate that, what you've done is, as I said before, meaningfully decrease the size of the pool of prospective buyers. If you are a person, a founder who has built a government contracting business through the use of small business set-asides. And so because you have a smaller pool of buyers, it's going to also decrease the values of how companies that have grown under these set-aside programs are sold when they're eventually sold.
Are there any benefits?
You know, it's a great question, and I've been thinking about this. I think the most likely benefit is that it's possible that the small businesses who will remain as potential awardees under these multi-award contracts could end up being more profitable. And my thinking is that if you have a larger entity in the past, if you have a larger entity that has purchased a smaller business and maybe has more resources to put into the development of the RFPs for the task orders, or is willing to take lower margins in order to get additional work, they could have ended up being the eventual winners under the RFPs for these task orders. If they're removed and you have a smaller pool of companies that are eligible for these additional task orders moving forward, it's possible that those task orders could end up being more profitable to the ultimate winners of the RFPs.
So let's move on to one of the other topics in the proposed changes. One of the other changes is that there are specific circumstances in which minority shareholders may have decision-making authority without breaking the SBA's affiliation rules. Two of those circumstances are the sale or the merger of a company. So Catherine, what potential impact from a legal perspective do you foresee regarding these extraordinary circumstances?
My take on this portion of the proposed rule change is actually quite positive, because by and large, what this change does is it allows small business owners with certain set-aside statuses to offer to their minority partners what I would consider market standard protective rights if they want to undergo an extraordinary transaction with respect to their company. And what the SBA is doing here by permitting these certain negative controls for the non-disadvantaged owners to exercise is it protects them. They've already given up their ability to impact decision-making or control of the company by and large, because that's required by the set-aside regulations. And we're talking specifically about programs like the Woman-Owned Small Business Program, Service Disabled Veteran-Owned Small Business Program, and 8A economically disadvantaged programs. The SDVOSB program, Service Disabled Veteran Program, already had recognized these 5 specific extraordinary transaction negative controls. So in large part, the rulemaking here is just bringing those other individually disadvantaged programs into conformity with what already existed. So it's bringing a little bit more cohesiveness and uniformity across the programs in this instance, which I think is beneficial. It also allows those business owners to go to potential economic partners, strategic business partners who they want to have involved and potentially offer a minority equity ownership stake in the company, and say to them, I can also give you these very reasonable rights to vote on major transactions that are going to impact whether or not you want to participate in that investment. So I think it will open up the ability for people to partner with these set-aside businesses and have what they would consider commercially reasonable protections.
Yes, that makes sense. So Andrew, is there anything you would add to that?
Yes, I think potentially this could be of great value to the business owners, because most small business owners are capital constrained. Bank lending standards have tightened up. Non-bank lenders are available, but only for the most secure type of collateral. By having the opportunity to take in minority investors, particularly as equity holders, I think it could give business owners access to capital that they, quite frankly, don't have today, and also lead to the formation of a different type of private equity firm. There are a handful of private equity firms that are currently making minority investments in government contractors. In all cases that I've seen so far, other than SBICs, they're primarily done with the larger company, larger contractors are primarily, working on full and open contracts. If the rules are enacted as proposed, I believe you could see an opportunity for private equity firms to form with the specific mission of making minority investments in smaller small business and other set-aside type focused government contracts.
Excellent, excellent. So there's good news. There's good news here in the
Potentially.
changes, potentially. One of the other changes the SBA proposes is in the percentage of ownership interest that a non-disadvantaged individual or company may own in, for example, an 8A company. Catherine, can you explain these proposed changes?
Yes, absolutely. So under the current rules, a non-disadvantaged individual is only permitted to own up to 10% of a developmental stage 8A company and up to 20% of a transitional stage company. And any changes in those numbers requires prior SBA approval before anything can be done to implement it, which it won't surprise anyone on this call to hear can take quite a long time. And often the timeline upon which SBA approval would be granted completely negates the value of a business transaction because the business world moves more quickly than the agency world.
Yes.
The new rule just increases those ownership thresholds to 20% and 30% respectively. And it also loosens the triggers that would require that SBA pre-approval for a change in ownership transaction to occur. So it provides really at the end of the day, a little bit more operating flexibility for owners who are perhaps taking on those small minority investment stakes to offer a little bit more or to have shifts, non-material shifts in those percentage ownership occur in a manner that can be timely and efficient without having to wait for SBA pre-approval. So this is going to help kind of streamline business operations overall.
Yes, I love that. So Andrew, are there any implications of this change for M&A transactions?
Again, I think it's the ability to access a different type of capital that has the potential to help these small business owners grow more quickly and have their companies better positioned for an eventual sale at some point in the future. Ideally, it will give them the capital to allow them to grow past the need to rely strictly on small business or STV or woman-owned or 8A type set-asides, because to state the obvious, the most valuable businesses are those that have won full and open prime contracts.
Great. So I want to make sure that I summarize this and understand it correctly. So both of you are saying that a non-8A company or individual can own up to 30% of an 8A company, which should encourage more investments in these 8A companies while they're in the program. Is that right?
That's right.
Okay.
Yes.
Okay, good.
And that's on top of the rule that allows those minority owners to have those 5, negative control against extraordinary transaction voting rights as well. So it also can, those combined, make it a much more attractive investment proposition to invest in those 8A.
Kind of sweetens the pot there. Good.
Exactly.
Good. The SBA also proposes to give 8A and WOSBs the ability to grant the right of first refusal to purchase their interest in the company to non-disadvantaged individuals. Catherine, what are the implications?
This is another instance of the SBA rules trying to bring the set-aside regulations a little bit more in line with market standard for business transactions of this kind. It's very common in privately held small companies to have mutual rights of first refusal among all of the owners that essentially says if you want to sell your shares, you can't just sell to anyone. It's a privately held company. You have to first offer those shares to either the company itself or to the other shareholders and let them buy you out before you transfer to someone else. Under some of the old rules, it was so strict as to say that if you, as the woman owner of a woman-owned small business, wanted to restrict yourself by signing up for a right of first refusal, which applies to all of the other shareholders, that would be an impermissible limitation on your ability to control your shares for the WOSB regs and could impact certification, which means that you would have to force your partners to enter into an inequitable deal, right? Even if you have no desire to utilize that right, the documents would have to give you free rein to transfer. So now what it does is it says, if we recognize that virtually every limited liability company operating agreement out there is going to have these types of rights of first refusal with respect to transfers of shares, we will permit the disadvantaged owners to sign up for those rights mutually, again, to make it a more, I think, combined attractive business investment for those non-disadvantaged minority partners to come on board and be protected.
Excellent. Andrew, does this affect M&A at all?
I don't think so, because, particularly in the case where you have a woman-owned or 8A business, I just am hard pressed to imagine circumstances whereby a minority partner would exercise the right of first refusal and buy the business, because by definition, they would not be able to continue to perform the work post-closing. So I think it's great that the SBA is bringing the way the structure of a minority investment is done more in line with what other private businesses do. But just in terms of transactions, I don't think it's going to significantly change the M&A world.
Okay. So, Catherine, when are these rules active? When do they, are they retroactive? What is our sense of that?
So in most cases, the rules, and I know you mentioned this at the outset, Shirley, but just to reiterate for everyone, what we've been discussing here is a proposed rulemaking. So none of this has been formally and finalized and adopted yet. When finalized, most of the rule is not going to be retroactive. However, it is important to be aware that the SBA, in their commentary on the proposed rule, has characterized some portions of it not as a new rule or a rule change, but rather has characterized it as a clarification of existing rules. And in particular, they have used that language to apply to the rules around recertification following a change of control transaction. So if the SBA is successful in characterizing these as a clarification, then they could decide that the applicability of that, impact of recertification post merger would apply to existing awards essentially retroactively, such that there may not be an ability, once the rule is final, for companies that have gone through an M&A transaction that hold these set-aside contracts and were not able to recertify. This may impact their ability to receive an option award or to submit future task orders. So if that is how this is implemented, it could be quite disruptive. We don't know for sure that will be the impact, but it is a possibility.
So where are we in the process of getting these changes implemented?
So the comment period has closed. And typically that would mean, based on where we stand right now, the comment period closed last month, we would expect the new rules or the finalized version of the rules to take effect sometime in 2025, most likely not until mid-2025, based on how these timelines usually play out. In this instance, the SBA has indicated that it is eager to get these rule changes implemented prior to any change in administration. So if they do stick to that signaled accelerated timeline, that could mean that these may be finalized as early as, say January 2025, which we'll see if that happens, but the SBA has indicated that that is their preferred goal.
Okay. So Catherine and Andrew, I want to wrap up our discussion so we can open the floor to Q&A. So I want to ask you one final question. What is your overall advice to small government contractors? Andrew, you want to go first?
Sure. I think the question I ask whenever I talk to somebody who's thinking about selling, whether it's soon or at some point in the future, is what are your goals? If you want to build a successful, what I would call lifestyle business where it's profitable, and you're not as concerned about what the final exit multiple looks out, these sorts of rule changes I see overall are going to be positive to you. But if you're looking to build a company where you're hoping to get a significant exit at some point in the future, you need to take them into account as you're growing your company. And the general advice I give is that you need to figure out a way to take the advantages you have today, reinvest into your company, and get to the point where you're relying on set asides as little as possible, because that ultimately will give you a better exit.
Good advice. Catherine, what are your thoughts?
I completely agree with Andrew that that strategic thinking and forward thinking in terms of how you view these set aside contracts in particular is critical. And it may very well change how business owners view set aside contracts. Now, I think there'll be more of a stepping stone and less the ultimate goal before an exit, assuming that the recertification rules take effect as they are. I would say right now, the most important thing small business owners can do is make sure that you keep yourself informed of the state of the law, such that you can adapt business strategies and approaches more as proactively as possible as these rules become finalized. So attend webinars like these, read the news alerts that come out, consult with your advisors once the rules are final to make sure that you really do understand what the landscape is. That can help direct your strategic decision making.
Thank you, Catherine. And I want to underscore the advice to consult with advisors. There are a lot of people with a lot of knowledge and experience that can help guide your business decisions. So this wraps up our formal remarks. We have a couple of questions here from the audience. I want to encourage others of you to also send us questions via the chat feature. The first question is, how do you see this rule playing out as it is practically implemented by contracting officers? And Catherine, you want to take that one?
It's a great question because some of the rules are, when you think about the practical impact, it's unclear as to exactly how that is going to be applied by the COs. I think that this is true in particular with respect to the change in eligibility for option year exercise. It's one thing to say that a company is not eligible to submit a bid for a future task order. That really just takes a potential awardee out of the running for that task order. But if you think about existing awards that have option years under them, existing task orders with unexercised option years, what's the CO going to do if prior to option year exercise, the contract holder submits a recertification notice and says, we've undergone a change of control transaction, we can no longer recertify it small. Technically, the agency is not able to exercise those option years, and they're going to have to figure out how they're going to get that work performed. This is in situations, again, where there are multiple awardees of that overall contract, but you could face a situation where you have task orders whose life extends past the lifespan of the primary contract vehicle, in which case, what mechanism is the CO going to use to transfer that work to another contract holder if the vehicle itself is no longer active? I think that it also potentially creates disruption for the customers, continued performance of mission objectives and things along those lines. So I think it is possible that we may see pushback from the contracting officers themselves when they're the ones who have to deal with the administrative and practical burden of implementing these SBA rules themselves. So that will be interesting to watch. I do not anticipate that it's going to just be a very smooth transition to that process. Also, keeping in mind that these types of transactions occur very, very frequently in the market. So COs might be dealing with these things, rapid fire, depending on what the M&A market looks like. All of that could result in some practical difficulties.
I anticipate that there is going to be a lot of disruption for contracting officers, knowing how busy their schedules are already. One last question here for clarification. If I'm an 8A firm, I can sell up to 30% of my company. Does this apply to SDVOSBs as well?
So for SDVOSBs, the rules are actually less restrictive. For SDVOSBs, the rule is that the service disabled veteran has to own merely a majority of the overall equity of the company. So you can sell up to 49% of your company equity to a non-service disabled veteran owner. And as long as you satisfy all of the other control requirements of the regulations, you would still be SDVOSB eligible.
Okay. Excellent. One more question just came in for Andrew. Is there any affiliation among small businesses with a common SBIC equity holder?
So, and I'd like Catherine's opinion on this as well. My understanding is the answer is no, because that would preclude the SBICs from making, from doing the type of investing that is their mission statement. So my understanding is the answer for that in that particular case is no. Catherine, did I get that right?
At a high level, yes. The important really crux of that is that the investor has to be certified as an SBIC.
Yes.
Because the answer is different if they are not. The SBIC certification is specifically grants that protection and enables them to make multiple investments in small businesses without the affiliation risk.
Right. So you just need to ensure, like Catherine said, that whoever you're working with is actually a licensed SBIC.
Good. I want to stay somewhat within our half-hour time frame here. If you ask some questions and we did not have a chance to answer it, we'll answer that via email. So thank you for your patience there. And thank you all very much for attending today. We will send out a follow-up email with the link to the SBA website. We'll also include some information, some contact information for Catherine and Andrew if you want to follow up with them. Catherine and Andrew, thank you so much for collaborating with me on this. You're very knowledgeable, and thank you for sharing it with the audience today.
Thank you, Shirley. It's been a pleasure.
Take care.